The next matter to come before us this morning is State of Ohio versus Tremayne Wallace. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you or the appellant wish to reserve any time for rebuttal, if you let me know when we get started, I'm keeping the clock and can keep you apprised of the passage of time. The court's read the briefs and are ready to proceed when you are.
Thank you, Your Honor. Your Honor, the appellant didn't ask for an oral argument, but the state did. Does that mean I still go first, or does the state go first?
You still go first.
Thank you, Judge.
Do you want to wait and see what the state says? I think you probably know from the brief, right?
Yeah, I pretty much know what both of us are going to say on this one. Thank you, Your Honors. I'm Attorney Ken Ortner, 006976, and the attorney for the appellant. Judges, Your Honors, good morning. This is an odd case for me because Tremayne Wallace was sentenced to 12 months in prison, and by my calculation, and not including any of the time he might have been in county jail and so forth, just his prison time, he's only got 57 days remaining on that sentence. And none of the crimes that he was convicted of require mandatory post-release control. So I'm not sure what his choice in this would be. I know what would be the logical choice, but I'm not sure that he would make the logical choice. So with that, the state's already agreed that this case should be remanded for resentencing because of the discrepancy between what Judge Burge offered Tremayne and what Judge Crawford ultimately sentenced to Tremayne to. It seems to me that that is a solution, but it doesn't seem to be the correct solution. When a court speaks, it should be more than just whichever person has to be is sitting behind the bench before they get removed from office or something, or somebody else gets elected. It seems that the court as an institution should be speaking from the bench, and that the judges that follow one judge would be obligated to enforce what the court has said, which isn't what happened in this case. I understand that...
Can I stop you there just for a moment? Because what I think I'm hearing is that if, I'll just use my colleague here, Judge Hensel, were to have been the trial judge and made a decision, and for whatever reason, I came in then as a visiting judge and was there for sentencing. If Judge Hensel's decision was clearly and convincingly not according to law, based on what you said, my obligation as an independent judge is to follow the promise that she made in indicating what the sentence would be.
You know, I don't think I've considered the possibility that these judges in this case would do something that was statutorily, that was impossible. And I don't think that was the case here, but if that is the case you're speaking of, yes, I do agree that, that you know, I don't think that you can do something that's contrary to law.
Oh, okay.
But in this case, what Judge Burge offered wasn't contrary to law. Tremayne relied on it in his sentencing and so forth. And I think that a person, especially a defendant who's standing in front of the court and has their life on the line, should be able to rely upon what the court informs them. And as far as the forfeiture goes, Judge Burge had said to Tremayne that we will have a forfeiture hearing to see if you can prove where the money came from or not. And just what Tremayne wanted was the money to be applied to his court costs and fines. He didn't want to get the money back for his commissary or anything like that. And seeing as that's what Judge Burge had told him at the time, it would seem that fairness due process would, and contract law would make the court obligated to follow those promises.
So you're looking pretty much for specific performance, for lack of a better term. You want, on remand, the court to have to follow the promise, not to, because case law suggests that the court has to either go along with the promise or to allow the defendant to withdraw his plea and to go forward and defend himself?
I would like specific performance on the part of the forfeiture so that my client can, if he has any proof of where he got the money, that money could be applied to the fines and so forth. On the other aspect of the law, especially seeing as Tremayne's only got 57 days left, I would be fine with the case being remanded and having him decide whether he wants to finish his 57 days or go on 5 years probation.
And with respect to the spec, the record apparently indicates that he pled to that. So how is it that he gets to have the judge look into applying it?
Only because the judge said he would on the record. We talked about it on the record, and at first we didn't think that there was any type of plea to the spec, and even when the judge realized it, is when he said was a sentencing, that we're going to talk about this. And so my client and I both relied on what the court had told us. Thank you.
It's an unusual case that I stand here today saying that the state concedes error in the trial court. After having researched the issue extensively, I think that the trial court was wrong not to follow the unqualified promise that Judge Burge gave this defendant under contract, under criminal, under whatever. That was a mistake that occurred, and I think just by way of context, what happened was we had a visiting prosecutor, or I should say a substitute prosecutor, who was reading notes in a file with a visiting judge who hadn't made the promise, and between the two of them, we got it wrong. And the state does admit that was error and takes responsibility for that. The question is, what should the remand order be? And I think this court's decision in State v. Bortner, which is a 2014 9th District case, says that when a trial court intends to deviate from an unqualified promise of a specific sentence, the defendant has to be given notice and an opportunity to withdraw his plea. And I think that this case should be sent back so that that occurs. It would be, in other words, I'm not saying that Mr. Ortner is wrong when he says I want specific performance. I just don't think that it's right for the Court of Appeals to send it back and say that's what you have to do. Because the trial court ultimately sentences, and what the trial court has the obligation to do in this case, given a unqualified promise of community control, is either to impose that sentence or to say to Mr. Wallace, I intend to deviate from that sentence, I'm going to do something different. And if you disagree with me doing that, then you have the opportunity to withdraw your plea. What would you like to do? At that point, Mr. Wallace and his counsel are certainly free to say, you know, I want to withdraw the plea, or I want to go forward and have the court sentence me to whatever is sentenced. I don't think that the specific performance would be the appropriate remedy. It should be whether the defendant is allowed to withdraw his plea after being given notice that the court intends to deviate from the sentence. I think that the case law is clear on that, and I would ask that the remand order be that the sentence is vacated and set for resentencing with instructions that the trial court comply with this court's decision in Bortner. As to the second assignment of error, which is the forfeiture specification, I don't believe that that issue is ripe for review, because what's going to happen is this is going to be sent back for resentencing, at which time the court can impose the forfeiture, not impose the forfeiture, whatever arguments the defense counsel wants to make. And any decision by this court would kind of be premature on that until we have a correctly imposed sentence on Mr. Wallace. And in fact, in the other scenario, if he chooses to withdraw his plea, then we're going to have a trial, and there's going to be an issue about the finding of guilt or innocence on that specification, and then a sentence either imposed or not imposed on that. And based on that, I think any decision from this court would really be premature, because the issue is not ripe until we determine what's going to happen on remand from the assignment of error from the first assignment of error, which the state has conceded. So I would ask that the court decline to address that assignment of error at this time as not being right for review and send it back for application of Bordner and for the defendant to be given an opportunity to withdraw his plea if he chooses to. Is there no questions?
This is unusual for Bernie and I to agree on anything. The only difference is it seems to me that in the interest of fairness and the fact that Tremayne's already been in prison for 10.5 months, that when he comes back for resentencing, that he should have the option of leaving the 1-year sentence in place, which would be the logical thing to do, and still be permitted to present evidence about whether the money should be forfeited or not. It's a small thing. He either has bank accounts, tax records, or something, or he doesn't. Thank you.
Thank you both for your presentations this morning. The court will take the matter into advisement and issue a written decision, which will be mailed to both sides, as well as posted on our website and the Ohio Supreme Court website.
Thank you.